appeal in the matter of Brave and others and Chedington Court Estate Ltd.
Yes, Mr. Demont.
My Lord, my lady, here with my learned friend Mr. Colclough for the appellants, Mr. and Mrs. Brake and their son Mr. Darcy. My learned friends Mr. Sutcliffe, Queen's Counsel, and Mr. Day appear for the respondent.
You say Mr. Darcy, I thought he dropped out of the picture. He's still a party, is he?
Still a party in these proceedings.
Right.
It was the possession proceedings, I think, that he dropped out
Oh,
in relation. Well, my Lord, as an advocate, one gets used to the fact that the bench may know more about the law than one does, but at least one normally has the comfort of knowing more about the case. I'm conscious that your lordships and ladyship have in various guises had more involvement with this case historically than I have, so you hardly need...
Not this aspect of
it. Your lordships hardly need me to mention that this case has a very complex factual background, yes, as I think my Lady Justice Asplin said expressly in her judgment in 2020. But fortunately, both sides to this appeal have been cooperative and helpful to the court, I hope, in boiling down the complex scenario to some bare factual bones from which we can analyse the legal position in a clean and objective way. And I hope the legal points arising are not uninteresting ones. And I'd like to pay tribute to my learned friends, my learned junior's skeleton argument in particular in achieving that. On the subject of skeleton arguments, I do apologise to the court for the lateness of my skeleton argument, or that which I produced with my learned junior on Friday after my late instruction on Thursday. I'm grateful to my learned friends for not raising any objection to it, but rather seeing it as a helpful document. And I hope
yes, all right.
Have your lordships been able to take a look at it?
Yes, we've read all the skeleton arguments and the judge's judgment.
Well, I'm very grateful to you for that, my lord. There is one additional point relating to the 1977 Act, which occurred to us yesterday evening, and which I immediately informed my learned friends about. It's a pure point of law. It arises from the statute, the wording of the statute. It's not a complex one. I have to say my learned friend does not agree to me raising it at the last minute, and I appreciate it is 11th hour, but perhaps we can park the point for now, and when the point arises in the natural course of my submissions, my learned friend can explain his objections to it, and I can ask for permission to rely on it. But it's probably one that your lordships have already observed in reading through the papers.
All right. Since it's mysterious what this point is, I couldn't possibly say.
Well, let's leave that mystery unsolved for now. My learned friend wants me to say something about the timetable. I think we're both conscious that there is a lot to get through in one day. I noted that the listing on Case Tracker gives a 6-hour time estimate, and of course that's more than more hours than there are in the day, as it were. I think I can finish what I want to say with my learned friend following by lunchtime, but realistically not much earlier than that.
Right.
That should allow my learned friend an equal time in reply, more or less, and I don't anticipate saying very much at all in reply to him.
Right.
I hope that's acceptable to your lordship.
Yes.
Mr. Sutcliffe, would you like to say anything on that? Well, I'm grateful. So turning to those bare bones, undisputed facts that we proceed from, they are for today's purposes the following: that the first two claimants, Mr. and Mrs. Brake and their son Tom, were in factual possession of the cottage, as at the 18th of January 2019, with the necessary animus possidendi on their own behalf at all material times, including and up to the date of eviction. It's not disputed that they had taken possession lawfully, pursuant to the terms of the partnership deed. It's not disputed that Mr. and Mrs. Brake were and are two of the three legal owners of the cottage, the registered proprietors. They have paper title, together with Mrs. Bremer. It's not disputed that at the time of the eviction, the whole beneficial interest in the cottage was vested in Mr. Swift, the trustee in bankruptcy of the Brakes from an earlier bankruptcy, although in fact the family didn't know that until a bit later. Also unknown to the family at the time, but not disputed, is that the trustee in bankruptcy had granted to Chedington, Dr. Guy's company, a licence for 2 years or earlier termination in relation to the cottage. 3 days later, after this licence, and 1 day after the hearing in Yeovil that your lordship will have read about, Chedington waited until the family was away from its home, then broke into the cottage by drilling out the locks and forcibly excluded the family from coming back in with security guards and locksmiths. Chedington did not just occupy the cottage, it took complete possession of it, purporting to exclude the world. None of that, in my submission, is in dispute. The only two things I would add to that background for today's purposes is first to remind the court that Dr. Guy had extracted undertakings from the family to the court in Yeovil the day before the eviction to leave the house and move into the cottage when requested to do so, by giving everyone the clear impression that his company would acquire the cottage and allow the Brake family to use it. But at that very moment that those undertakings were being extracted and given, he was instructing his team of locksmiths and security guards to take possession imminently. The second bit of background I would add is the connecting factor between these proceedings and the proceedings that were before your ladyship in 2020. That the transactions between Mr. Swift, the trustee in bankruptcy, and Dr. Guy and his companies in January 2019, culminating in the very licence that is in issue today, the underlying complaint in those 2020 proceedings, your ladyship will recall, is that Dr. Guy or his companies paid a so-called facilitation fee to Mr. Swift. That licence is therefore being sought to be set aside, and those proceedings are before the Supreme Court in November this year on the trustee of bankruptcy's appeal. If, of course, the licence were set aside, that would be of great relevance to us today, but I accept it hasn't been yet, and therefore we have to proceed on the assumption that it is valid. So I accept that. So the only point where the court may have to grapple with any sort of factual dispute is in relation to residence. In relation to that, insofar as the point arises, Maloney Jr. Mr. Colcuff will address your lordships in following. And as he will say, he's proceeding on the basis of...
But what does it add? I think you accept, I understand, that breach of the Protection from Eviction Act does not give rise to a statutory cause of action.
Yes.
So if you succeed on either grounds 1 or ground 3, what difference does it make whether Section 3 of the Protection from Eviction Act was or was not breached?
Well, the structure is, as to the first two grounds of appeal, the first is obviously that Chedington had no better right, no title or no better right to possession than the family. That's the first ground of appeal. If I lose on that, and Chedington does have a better right to possession, then the 1977 Act may be engaged. Because the way the 1977 Act operates is to make eviction without a court order unlawful, even if Chedington has a better right to possession than those in occupation. Indeed, in fact, it only applies if Chedington does have a better right to occupation, to possession rather, than the family. And the Act, as your lordship says, operates by depriving the defendant of its, depriving the defendant with the better title of its defence based on that better title to the trespass arising from the re-entry. We get that from the McCall and Abelez case in relation to the predecessor statute and the current statute under Smith and Kahn. So we have an either-or situation with grounds 1 or 2. Either will do, and they are true alternatives in the sense that if one is right, the other one can't be, and vice versa.
Right.
When it comes to the third ground of appeal, my own friends in their skeleton argument say that it is entirely contingent on the first two grounds and address no submissions to it whatsoever. And what I had understood from that is that it essentially conceded that it stands or falls with one of the first two grounds. My own friend, I think, resiles from that slightly now and says that he may wish to make submissions that a right to possession doesn't arise even if we win on grounds 1 or 2. I think...
Well, ground 1, I think, claims damages, effectively. Ground 3 claims the order for possession.
Yes, I mean, ground one essentially raises the question: did the family have the better right to possession? Did they have better title? And we say the judge was wrong on that.
Let's suppose that they did, and let's suppose that they are entitled to damages. Would they not hold those damages on trust to the trustee? He has the whole beneficial interest.
Well, that is a different issue, of course. This is two
Well,
parties.
maybe, but it looks like a rather circular.
This is a two-party issue. That trustee no longer is trustee. In fact.
No.
But I take your lordship's point. But it's a question for another day, if I'm respectfully say so.
Well, chopping it up into yet more bits of litigation.
The trustee could have been involved in the litigation thus far, but has not chosen to be.
The other thing that puzzles me, and I might as well mention it now, is what right does a trustee under a bare trust have to occupy the trust property for his own personal benefit? Sounds to me suspiciously like trustee making a profit from his office as trustee.
Yes, I'm alive to that point, my lord, and I will address it. On the first ground of appeal, the judge's reasoning forms something of a chain. So I say if I can break any link in that chain, I've been on the first ground. On the second ground of appeal, it's the other way around. There's a whole smorgasbord of different reasons why the 1977 Act doesn't apply, and I need to shoot them all down to succeed. I suspect that it will come down to the point about residence, because the underlying policy of the 1977 Act is very clear that if there's someone in residence in premises who entered lawfully, pursuant to a tenancy or license, then the Act prohibits re-entry without a court order. Lord Templeman, I think, put it in one case as the dubious and dangerous method of enforcing a right of re-entry without due process of law. So that's the policy behind the Act. As to the issue of damages, my lord, before I get into ground one, we are, I think, agreed between my learned friend and I that that is an issue. The assessment of damages, you'll be relieved to hear, is an issue that we're agreed should be remitted to the court below should we get to that stage. So, my lord, turning to the first ground. The first ground is expressed in the grounds of appeal as whether the family had better title to the land than the respondent. And the real question is who was entitled to possession, but the starting point for that is title. That means both their paper title and or their possessory title. Title to land gives someone a right to possession of the land. Even a pure trespasser has a better title, a superior right to possession than a later trespasser. I hope that's not a controversial proposition. Clark and Linsell in the supplementary bundle, the wrong extract was included in the original bundle, but the extract is in the supplementary authorities bundle, is cited for that. But it's not a dispute. So the family's title is in fact clear. And to be clear, the family does not rely on its license in this regard. The license had terminated by the time of the eviction, and that is common ground. That license is essential to the second ground of appeal, the 1977 Act claim, of course, but we don't pray it in aid in any way on the first ground of appeal. So the focus of our inquiry under this first ground of appeal is therefore what title the respondent had when the team went in, having been tipped the wink by the neighbour. We say it had none at all. And as at today's date, its contract to buy the cottage has fallen through and its own licence has lapsed. Its only title now is its possessory title, and that is an inferior.
Sorry, the contract to buy the cottage had fallen through?
Has fallen through. The conditions to which it was subject have not been.
Well, they hadn't yet been satisfied. You say it's fallen through. I mean, the contract had gone away, or was still a conditional contract waiting for fulfilment of the conditions?
As I understand it, Mr. Swift has not has been removed as trustee in bankruptcy, and his successors have not adopted the contract.
No. Do they have to adopt it? Is it not?
Well, may I turn my back for a moment? Simpler than that. There's a long stop date on the contract, and that has passed without the condition.
That had passed by the time of the entry, had it?
No, it had passed by now.
Now, I see.
It was only 3 days before the entry, so no, it hadn't passed at that point.
Yeah.
But as at now, there's no license. So its only title now is its possessory one, which I say is inferior to the family's one. And if Chedington had no title at all, then prima facie it was not entitled to take possession from someone in possession, let alone to take it from someone with a legal title. And I say prima facie because then there is the question of the effect of the licence that Chedington had. It's the only licence that is in any way an issue in this first ground of appeal. May I take your lordship to the terms of the licence, because they are important, and this is the supplementary appeal bundle, which I'm referring to as B.
What about Mr. Swift's letter of the 15th of January, which was fixed to the door?
Yes.
That authority from him.
Let's look at that as well when we look at the licence. Tab 4 is the licence. I hope your tabs are in the right places, my lord, because the index went slightly awry on the supplemental bundle. I can hand up a fresh index if it will assist, but hopefully if your tabs are in the right places, there's no problem. It's page 58 onwards.
Yeah.
The first thing to note is recital F. The licensor is permitting the licensee to occupy the property as licensee only insofar as the licensor has the right, title and interest to do so pursuant to the deed of assignment. And then clause 2, subject to clause 3 and clause 4, and only insofar as the licensor has the ability to do so, the licensor permits the licensee to occupy the property for the permitted use being defined as a residential property, for the license period, in common with the licensor and all others authorised by the licensor. And there's also 2.2.2, 2.2.3,
Yeah.
which are relevant. So it is heavily caveated. And crucially, it does not create a right to exclusive occupation or exclusive possession, therefore. It is not a lease, it is not a tenancy, it does not create an estate in land. All that is common ground. Chedington would have no complaint if Mr. Swift and his family moved in with them, curious though that may sound. It's not expressed as a contract of agency. It's not expressed as a delegation of powers. It's clearly not a delegation on its face. It's just a permission. And the licensor expressly retains his powers in relation to the property. And that, in my submission, is supported by the letter at tab 6, which your lordship refers to. In the penultimate paragraph.
Sorry, I'm not with you.
It's,
Five,
is it,
I think.
is it 5?
Page
Right,
65.
okay, your tabs aren't in the same places. But is it page 70 in your...
No, 65.
Right, I see. I've got a bundle that has a TR1 form in it as well. Never mind. I'll ignore that.
No,
So tab 5, page 65. And the penultimate paragraph says, on the basis of my interest in the cottage, I have today granted a licence to occupy the cottage, the Chedington Court Estate, indeed he has, with immediate effect. Please take this letter as confirmation that employees and agents of Chedington Court Estate have my authority to enter and use the cottage in accordance with the licence to occupy that I have granted. And this letter is evidence.
Well, yes, but the couple of paragraphs up, he says, as from today, I'm entitled to possession and unfettered access to the cottage,
Yes.
I'm entitled to use reasonable, lawful and appropriate measures to get entry to and secure the cottage. Chedington have my authority to enter.
In accordance with the licence.
Yes, but in order to enter, they are, I would have thought, they have his authority to enter.
Yes.
That's what they did.
But what they don't have authority to, under either this letter or the licence, is to exclude others.
Right.
But yeah, that's what they purport to do. They have permission to enter, they have permission to occupy, they do not have permission to take possession. And note that it talks about the agents of Chedington, not the agents of me. So it's not an agency, and it's not a delegation in that sense.
Yeah.
So it comes down to who, between the family and the respondent, had a better right to possession on the 18th of January 2019. And I do emphasise the word right to possession, because we're not interested in the question whether, if the respondent had applied to court, the court would have granted it a discretionary remedy. It didn't apply. We're not interested in whether, if the respondent had asked the legal owners, they would or should have granted it a right to occupy or possess in the exercise of their administrative powers under the Trust of Land. It didn't ask, and they didn't give it one. And Lord Millett said this in Foskett and McEwen, and it's a passage that's quoted in the Mark Monacott book. I don't need to take your lordships to it, but the quotation from Foskett is this: property rights are determined by fixed rules and settled principles. They are not discretionary. They do not depend on ideas of what is fair, just and reasonable. Such concepts, which in reality mask decisions of legal policy, have no place in the law of property. So that's orthodoxy in property law, in my submission. So if Chedington was going to re-enter without an order, it had to rely on a self-standing right to possession. Its right to possession had to be as of right, not, or well, it had to be a right as of right, not just a right that could be granted or might be granted. And so we say such a right can only be a better title. Well, Chedington had no paper title. It had no prior possessory title. All it had was this non-exclusive license to occupy, which was granted not by the legal owner, but by the beneficial owner. And so the way we break it down is like this, my lord. First, a licensee of a legal owner has no estate in land, that's common ground, and no enforceable right to possession against anyone except the licensor. Only the licensor has a right to enforce the licensed right as against a third party. It's because it's a contract. And the only caveat to that is Manchester Airport and Dutton, which we'll come to. But you've seen from my supplemental skeleton that we say it doesn't assist the respondent. And we say, secondly, that a beneficial owner is not entitled to possession as of right against the legal owner, save insofar as statute confers such a right, which we say it doesn't here. And we say, thirdly, a fortiori, therefore, that a beneficiary is not entitled to enforce a possession as of right against a third party, and even more so, the mere licensee of a beneficial owner can have no right of possession, not against a third party, not against the paper title owner either. The beneficial owner can't assign a right it doesn't have. And even if it could, again, the first point applies, the license is just a contract between the licensor and the licensee. It does not bind third parties. Is that conclusion caveated by Dutton? We say no, because that would be extending the reach of Dutton, and I suggest there's no legal justification or judicial appetite for doing so. And both of these points about the limits of what a beneficial owner can do against a third party, and about what a licensee can do against a third party, are illustrated and underlined by equivalent procedural rules. As regards an equitable owner who wishes to enforce a right of possession, to possess the whole of something, has to join the legal owner as a party. That's in the Wanacott book at page 944 in the third bundle of authorities. In that case, it gives the example of an equitable assignee of a chose in action. But the proposition is a universal one, as is clear from Ali Akmon, and total and shell, which is tab 24 in the second bundle of authorities. I can take your lordships to that if you'd like, but I'm sure it's not a controversial proposition. In the same way, a licensee, even an exclusive licensee, if he wants to enforce his right to exclusivity against whatever it is, against a third party, he or she needs to join the owner to the claim. And my Lord Justice Arnold will know this better than any of us, that's true commonly encountered in the field of intellectual property.
Indeed. Yeah.
It's only by virtue of Section 101 of the Copyright and Design and Patents Act 1988 that an exclusive licensee has a right to bring an action against a third party without joining the legal owner, the copyright owner.
Well, this, on your ground one, we're not concerned with legal actions, are we?
Yes. Well, it's maybe that your lordship and I have slightly different conceptions of where the boundary between ground one and ground three lie. Essentially, what I'm proposing to argue under the head of the first ground of appeal is that that as of the 18th of January 2019, Chedington had no right to possession as against the family. It comes down to that, simple as that, really.
Yeah.
As to what consequences flow from that goes to, the way I've structured it at least, it goes to the third ground of appeal and possibly the assessment of damages as well. And similarly, we know that licenses give no proprietary right in intellectual property, just going back to the point I was making. We know that licenses give no proprietary right in IP, just as licenses in respect of land give no estate in it. So that's all common ground, I hope, and uncontroversial. So, what rights does a beneficial owner have against third-party trespassers? I won't say much on this because I don't perceive it to be much an issue. Action for trespass is a common law action, so a beneficial interest won't allow a claimant to sustain a claim in trespass. As we've seen, an action in trespass has to be brought by, or at least in an action joining, the legal owner. Unless, of course, the beneficiary is already in physical possession of the land, in which case the beneficiary can rely on its superior possessory title. But that wasn't this case, of course. The trustee in bankruptcy was not in possession of the land. So then we come to look at the position of the beneficial owner as against the legal owner, and this is touching on the point that your lordship was making a moment ago. The starting point in the learned judge's argument is to say that the beneficial owner has a better right to possession than the legal owner. And he gets to this erroneous conclusion in paragraph 198 of the judgment. This is at page 102 in the bundle.
98, you say?
It's paragraph 198.
198.
Yes. This is the paragraph where he talks about not needing to cross Westminster Hall.
Yes.
So my submission, he gets to that erroneous conclusion by asking the wrong question. Instead of asking, did the beneficiary have a right to possession entitling them to enter without recourse to the court, he asks himself a different question, whether if a trustee brought a claim for ejectment under a beneficiary in possession, the beneficiary would have an equitable defence under trust law. And that's the wrong question because it's simply not what happened. But then he also provides the wrong answer to my submission. The learned judge says the beneficiary might obtain an injunction to restrain the action in ejectment on the grounds of a failure to allow the beneficiary to occupy. If he meant might, in the sense of might or might not be granted an injunction, then clearly that's not enough to support the argument that someone's entitled to do it without even asking. If he meant the beneficiary would be entitled to an injunction as of right, with respect, he's simply wrong. Because prima facie, the decision of who gets to occupy a trust property belongs to the trustees. A beneficiary, even a beneficiary under a bare trust, has no entitlement to occupy unless it is given to him by the legal owner, the trustee, or by the court, or by statute. And my lord, that is clear from the additional authority that I put in. I only put in it for one short paragraph from Lord Justice Millett's speech in Ingram and IRC, the well-known tax case, which is in the supplementary bundle of authorities, tab 11 at page 424. That's page 115 of the bundle. And the facts of that case were briefly that Lady Ingram was seeking to avoid tax by, I think it's called shearing by the tax bods, where you grant yourself a lease in effect. But she wasn't granting herself a lease, she was granting a nominee, a bare trustee, a lease. In order to separate the legal and the freehold and leasehold titles in the property. And Mr. McFadden was the nominee, the bare trustee. And what Lord Justice Millett says at D on page 424 of the report is he was not independent of Lady Ingram, but neither was he a mere cipher. His duty was to deal with the land as Lady Ingram might direct. He was bound to convey the land to her, or to whom she might direct. That's the Saunders and Vautier right that all beneficiaries collectively of their sui juris have. But he was not bound to comply with other directions that she might give. He could not have been compelled to grant the lease, though if he had refused, Lady Ingram could simply have found someone willing to do her bidding and require Mr. McFadden to convey the land to him. It is not, in my opinion, correct to identify Mr. McFadden's mind with Lady Ingram's for the purpose of the two-party rule. And that passage is expressly approved by the House of Lords, Lord Hoffman, and I've put the judgment in at the next tab. So the reason that it is possible to grant a lease to one's nominee is because the nominee is not a mere cipher. The nominee does not have to do whatever the beneficial owner says. The bare beneficial owner's rights are to say, transfer the legal title to me or to someone else that I direct, but not to how to exercise their administrative powers. So I'm afraid that Mr. Justice Haddon Cave, as he then was not right, or was at least oversimplifying matters in the AAZ and BBZ case, which is a divorce case, a financial remedies case. Though doubtless what he said was a sufficient analysis for the purposes of that matrimonial finance context, when he said that the nominee is essentially a dummy. But that's an oversimplification. And for the same reason, Mr. Justice Ungood Thomas, his remarks in the Hodgson and Marks case, famous case on overriding interests, were actually obiter when it came to the nature of the bare trust. In any event, they went further than they should, according to the House of Lords' view in the Ingram case. My learned friends say that it would be contrary to the notion of a bare trust of land if a trustee could prevent a beneficiary from enjoying the land. But that is not the corollary of what I'm saying. It's not that the trustee could prevent the beneficiary enjoying the land. Obviously, the proceeds of the land are held for the beneficiary. The point is that the choice whether to sell it and invest the proceeds, or let it and produce a rent, or let the beneficiary into possession, him or herself, is the trustee's choice.
Well, I see that. But how does the trustee legitimately say, I'm going to occupy it myself? Now, you've provided us with section 6 of Talata.
Yes.
Somewhere.
Yes, I was going to come to Talata right now, in fact.
Yeah, tab 3. And you've referred us to section 6.1. For the purpose of exercising their functions as trustees of land having relation.
We should
all
look
trustees of the absolute owner. And then you go down to subsection 6. Powers conferred by this section will not be exercised in contravention of, or any order made in pursuance of, any other enactment or any other rule of law or equity. Or is it not a rule of equity the trustee can't profit from the trust?
Yes.
So how do the breaks in exercising their functions as trustee claim to be entitled to occupy the trust property for themselves?
That's not the point I make at all, my lord. With respect, the point is not that the breaks are entitled to occupy it. The point is that the beneficial owner is not entitled as of right to occupy it. Now, it may be that if Mr. Swift had gone to court and said, I want a possession order, not because I have better title, but brought a trust action, saying these trustees need to exercise, and join Mrs. Bremer, the legal title owner, and said these people really need to hand it over to me, the court would agree with them. But that's not what happened. If nothing had happened to turn the beneficial interest into a legal interest or into a right of possession. There could have been a Section 14 application under the Trust of Land Act, but that didn't happen. And that's the point. I referred your lordships to...
So you're saying he could have sought to bring down the trust, or he could have sought the removal of the present trustees because they weren't conducting matters properly.
Yeah.
And those were the steps that he could have taken.
He could have exercised his Saunders and Vautier right. Mm-hmm. He could have removed the trustees under sections 19 and 20 of the 1996 Act, or under the court's equitable jurisdiction. Or he could have gone to the court under section 14 of the Act and said, I want you to direct the trustees to exercise their discretion to allow me into possession. So those were his options, but he didn't do any of those things. He chose a sort of what I might pejoratively describe as a backdoor route, the dubious and dangerous route that is deprecated by Lord Temple. So, in relation to maybe I don't need to go through the Trust of Land Act in as much detail as I was going to, but I was going to point out that it does include a bare trust. It expressly extends to a bare trust.
Sorry, can you help me on that?
Yes. So it's tab 3 in the Supplementary Authorities bundle is the better copy of the Act. Section 1 says a trust of land is any trust of property which consists of includes land. And under subsection 2, a trust includes a trust for sale and a bare trust. And then at section 6 of the Act, it refers to the general powers of trustees. Subsection 1, for the purpose of exercising their functions as trustees, the trustees of land have in relation to the land subject to the trust all the powers of an absolute owner. I say subsection 2 of that makes it clear that, again, that if it needed making clear, it doesn't really. But
what function of the trustees were the breaks exercising in occupying the property for themselves?
They weren't. I'm not saying that they were. I'm not defending the wrongfulness of their occupation. The point I'm making is that no one had a better right. Consider them as trespassers.
Yeah.
Nonetheless, they have a better right to a later trespasser. The point I'm making is not about the identity of the trustees, it's about the status of Mr. Swift as a beneficial owner only. Now, when it comes to the entitlement to occupy trust property under section 12 of the Act, that's at page 33, there is clear High Court authority that it does not apply to office holders. This is page 33. So a beneficiary who is beneficially entitled to an interest in possession in land subject to a trust of land is entitled, by reason of his interest, to occupy the land at any time, if at that time the purposes of the trust include making the land available for his occupation, or the land is held by the trustees so as to be available, but not if the land is either unavailable or unsuitable for occupation by him. So it was a case of mine some years ago in French and Bartram, where I picked up on what was said in the House of Lords in Stack and Dowden, where I think both Lord Newburger and Lord Hale said that the occupation rent regime has been replaced by compensation under the Act. So I argued that the trustee in bankruptcy does not have a right of occupation under the Act because it is not suitable for him, it's not held so to be available for him. The purposes do not include that. Therefore, I said, he cannot be excluded. There is only one person with a right of occupation, which was the wife of the bankrupt in that case. Therefore, the power to award compensation under Section 13 of the Act, which applies when someone who has a right to occupation is excluded, does not arise. Now, all of that was accepted by Mr. Stephen Davis, QC, as it happened to be on the other side, and by Mr. Justice Blackburn, as it happened to be before whom I appeared, apart from the idea that the whole of the occupation regime had been replaced by the compensation regime. And Mr. Justice Blackburn held no, the occupation rent regime continues alongside the compensation regime. And that was the decision. So I lost that case, and the same argument was essayed again in the Davis and Jackson case more recently, and again the same result was achieved, and that was Mr. Justice Snowden, as he then was. Again, accepted the premise of the argument that a trustee in bankruptcy does not have a right of occupation under Section 12, for the reasons I've outlined. So without an absolute entitlement, the beneficiary's right as against the trustee is qualified in the ways I've said. There is a discretion involved, whether that be the trustee's discretion or the court's discretion. If the trustees say no, and even if that's not a realistic position for them to take, and I take from your lordship's point that your lordship does not think it is realistic for the breaks to say no if they had been asked, but if they say no, even if it's unrealistic, the beneficiary has no right to take possession without first having gone via Section 14. Where it's a bare trust, for the reasons my Lady Justice Asplin mentioned, the reality is that a trustee is extremely unlikely to say no, because if they do, they'll be removed. But the principle remains that these administrative powers belong to the trustee. And the case that your lordship drew to our attention, the Attorney General and Lord Gore case, hard though it is to follow, actually supports that contention. And this is at tab 5. And the relevant passage is on page 45 of the bundle, 592 of the English reports. I think it's 150 of the original nominate reports.
Sorry, which page?
It's 45 in the bundle, my lord.
Yeah.
About 8 lines down. And what the court refused to do in that case was to uphold some leases that had been granted by the corporation to nominees for itself. The reason being that the corporation had done this in order to evade the consequences of having its charter removed by the Crown. And subsequently, the policy was reversed, and King James II restored the charters to the corporations, and everything carried on as if nothing had happened. But the question is whether these leases that had been entered into in anticipation of the removal of the charter were going to be upheld or not. And one of the grounds that is advanced for not upholding this lease is this. What ground is there? This is, 8 lines down from the top of the page. What ground is there for a court of equity to take the possession of an estate from Seti Trust and to deliver such possession to the trustees unless there was some gross mismanagement in the Seti Trust? This court never takes the possession from Seti Trust unless there is some strong reason for doing it, especially where there's been a length of time, as in the present case there was. So it's slightly different from this case because, of course, here the beneficiary is already in possession of the lands that are subject to the lease. The corporation never gives up possession. But although it's saying it's unlikely, it's saying that there is a discretion to turf out a bare beneficiary under a bare trust in appropriate cases. So it's a bit like Ingram, in fact, in that respect. My primary submission, I suppose, in relation to that case, that it's so obscure factually that no discernible principle can no discernible principle can sensibly be derived from it. But what commentary there is actually supports my position in my submission. Let us now look, if we may, at the Hawke Recovery and Hall case, which is the second bundle of authorities, tab 29, 524. And this is a decision of Mr. John Baldwin, Queen's Counsel, sitting as a Deputy High Court Judge, on appeal from Paul Matthews, as he then was, sitting as a Deputy Master.
Sorry, so that's volume 2, tab
29.
Thank you.
Sorry, my lady. I need to sort myself out for a moment. And it's on Judge Matthews in the judgment says that this decision doesn't help in this case because the reasoning of the Deputy High Court Judge was based on the fact that a beneficiary under a bare trust had obtained an order already that the trustee convey the legal title to, had already exercised his orders of voce right and had that vindicated by the court. And B, that the beneficiary had actually applied to the court of possession. And neither of those circumstances apply here, as the judge noted in his judgment. But it is instructive to look at Deputy Master Matthews' reasoning, which is quoted in paragraph 44 of the judgment given by Mr. Baldwin, Queen's Counsel, which is at page 528 of the bundle of authorities. And I'd perhaps just ask you to read the quoted paragraphs 23 to 25.
The claimant is the beneficial owner, is that right? And the first and second defendants are the legal owners?
Yes. Claimant is Hawke Recovery, which is a vehicle of the famous Mr. Baxendale Walker.
Yeah.
Now, I take with a pinch of salt the fact that Mr. Thomas Grant, QC, with characteristic flair, described that reasoning as contrary to all known jurisprudence, especially that which has developed since the Norman Conquest.
Where does he say that?
This is in paragraph 2 of the judgment of the. I assume that those words come from counsel rather than from the judge.
Yes.
But in my submission, that reasoning cannot be faulted so far as it goes.
The Deputy Master's?
The Deputy Master's reasoning cannot be faulted. So it's ironic that he somewhat disowns it completely when it comes to the case before him today. Where he went wrong, where the Deputy Master went wrong, is in not appreciating that the court would of course grant an order for possession as a remedy to enable the beneficiary Hawke to enforce its earlier order that the trustees must convey the property. The trustees were in contempt of court. They had been directed to convey the legal title to the beneficial title, to the beneficiary, but they had, in contempt of court, refused to do that. So all the court is doing in Hawke is making an order that will enable the beneficiary to enforce that previous order. But on an application for possession, which had been made, and as the learned judge says he had failed to appreciate when he sat as deputy master in this case, when the beneficiary having made that application for possession, the court was plainly entitled, but not bound, to make that order.
Well, if you've got a beneficiary fully entitled in possession, who calls upon the bare trustee to convey, that is his right, is it not? It's not a question of discretion for the
Right.
court. That's his right.
Yes, and that's what had happened in the Hawke case.
And normally speaking, orders of the court give effect to pre-existing rights. They don't create them.
Yes, and the Saunders and Vautier right exists.
Yeah. So why does the fact that the court had made an order for possession affect the legal rights? The right was the right to have the property, and with it, therefore, the right to possession.
The order that the court had made previously, I think this is Deputy Master Mark, made,
Yeah.
was to declare that that it was a bare trust and to order the conveyance of the legal title. And that had not happened, and that was the contempt of court. What I'm saying is that by way of a remedy to enforce that order for conveyance, the court was entitled, but not bound, to make an order for possession as opposed to conveyance of the legal title. Because, of course, the possession is the first step to being able to sell the land.
Yeah.
So that case doesn't mean that a beneficial owner necessarily has a better right to possession, even with the benefit of an order for conveyance of the legal title. And Hawke, in that case, did not do what Mr. Swift or what Chedington have done in this case. He didn't just break in, it applied to court. And absent any application by Hawke, absent the order that had been made for possession, the Deputy Master would have been right. The beneficial owner doesn't have a better right to possession than the trustee. So properly understood, Hawke is not a case about relative title or about a right to possession. It's another case about remedies akin to the Manchester Airports and Duttons case. May I move on to the point about licensees now? I think time is running away from me slightly and I need to press on. Looking first at the orthodox position, as we've said, the starting point is that the licensee has no estate or title of its own. That's still the law and it's not in dispute. A licensee, by definition, has no right to exclusive possession. If there is a contract granting a right to exclusive possession, then it is a tenancy. That's Street and Mountford. Drummed into be at least at university in the 90s. A tenancy is an estate in land, a license isn't. But a licensee without a right to exclusive possession, without any estate or title to the land, without any in rem rights, the obvious point follows: what right can the licensee have to to evict a squatter or anyone else? And the answer in my submission is no right at all, unless it is appointed as the legal owner's agent to enforce the legal owner's own right to evict the squatter on its own behalf. So, a locksmith, for example. The judge seems to think, or seems to say, that the person with the right to possession can give a licensee the right to evict by delegating the exercise of that right to the licensee. That's paragraph 199 of the judgment. And then he says, the licensee occupies in right of the licensor and on the licensor's behalf. Let us assume, for the sake of testing this, that the licensor is the legal owner and does have a right of possession superior to those actually in possession. And I accept that it's possible for a legal owner to appoint an agent to take possession on the legal owner's behalf. Indeed, a company would have to operate through agents, and always has factual possession or occupation through its agents. And one can say that those agents have a license to be there, and they are there in right of the company. But that's not the same thing as saying that a license to occupy gives them rights against third parties. That's heretical. It's their role as the licensor's agents which give them that right to evict third parties. And that's where the judge's reasoning makes a leap. He appears to treat Chedington as the agent of the trustee in bankruptcy, not only occupying on the trustee in bankruptcy's behalf, but also expelling others on the trustee in bankruptcy's behalf. But that's not the nature of the arrangement at all. The trustee in bankruptcy is not paying Chedington to carry out its statutory role for him. It's not delegated any powers to him. It's Chedington, on the contrary, is paying the trustee in bankruptcy for the right to occupy the cottage on its own behalf and for its own benefit. So with respect, the judge has got that entirely upside down. And the cases that my learned friends have added to the bundle confirm this. There's two of them. There's Bertie and Beaumont from 1812, which was the case of a hired servant living in the master's property. And a right of way to the property was being interfered with, and the master sued for the interference with the right of way, and the defendant, the interferer, objected on the basis that the master was not in possession because the land was occupied by his tenant. And the court said the servant was not the tenant of his master.
But is it right to treat all this as, in a sense, seamless? I mean, you might say, might you not, well, the trustee in bankruptcy authorised Chedington by the letter of the 15th of January to enter and take possession of the cottage with a view thereafter to the trustee, or immediately the trustee, granting Chedington the non-exclusive licence. Well, they took possession for at the same time as the grant of the licence. They're not occupying as licensees, but they took possession on the trustee's behalf.
It is seamless in my submission in the sense that the letter that we referred to expressly refers to the licence. It says this is a letter confirming that the licence is a real licence.
Yes, but the trustee couldn't implement the grant of the licence unless he had possession.
He clearly anticipates that Chedington's going to try and take possession, or is going to at least going to enter.
Yeah.
But in my submission, that licence wasn't sufficient. The Mayhew and Suttle case was essentially the same. Suttle was a brewer, and he was the tenant of a house, and he agreed to let Mayhew come into the house to sell Suttle's beer for him. And Suttle then re-entered without giving Mayhew the agreed period of notice. So Mayhew sued for trespass. And Suttle defended the case on the basis that Mayhew was his servant. And that argument was accepted, slightly surprisingly. But given the direction in which consideration was travelling, but nonetheless, the court accepted that Mayhew was Suttle's servant and therefore he wasn't his tenant. Consequently, Mayhew could not maintain an action for trespass against the owner. So given that it was found that he was a servant, an agent occupying in right of and on behalf of his principal, the case supports my argument, not my learned friend. And the comments of Lord Briggs in the Bannerman case in the Privy Council don't really take this argument any further. That's a case about adverse possession. A squatter who takes possession for himself and then allows someone else in, continues in possession for the purpose of time running. That's the point. Even though he's no longer in occupation himself. And the licensee of the squatter can't then claim adverse possession against the first squatter. But that doesn't suggest that the licensee of someone with a right to possession who is not their agent is entitled to take possession against a third party. It's a different scenario entirely. And if this argument about Bannerman were correct, then in my submission the issue in Dutton would never have arisen. So let's come to Manchester Airports and Dutton. As your lordship knows and has had pressed on him in the previous cases, this is a decision that's proved very controversial among academic commentators, and many have argued it's decided per incuriam. And the court's reasoning does contain certain statements which at first sight appear heretical. Indeed, ironically, it was my own friends who in the court below argued that it was decided per incuriam, not those representing my client. But the judge rightly held that he was bound by it, and although we would want to reserve our position on it for a higher court if it came to that, we're content to treat it as correctly decided for today's purposes.
Well, I think it's binding on us, isn't it, whether it's correct
I
or
mean,
not.
Yes, but in the way that it was explained by your lordship in the vehicle control systems case.
I know Mr. Wonnacott has been on a crusade for years.
I hope your lordship doesn't feel personally attacked.
No. But he's run the argument. He ran it in Mayor of London and Hall. He ran it in Global and Laliva. He eloquently displays it in his book.
He's clearly just waiting for the right opportunity to
Absolutely.
take it to the Supreme Court. But, well, unfortunately, he's not here today. You have to put up with me. The facts in the National Trust case was that, of course, the National Trust was in possession of the land. The squatters arrived. Therefore, the National Trust could have evicted the squatters itself if it wanted to, even if it had no right or title other than its possessory title. In fact, it did have legal title, but presumably the National Trust didn't want the adverse publicity of taking proceedings against protesters.
Sorry, I haven't turned it up. Where is it in the authorities bundle? I take it you wanted to have a look at it.
It's tab 18.
Volume 1, I think.
In volume 1, yes.
Yeah.
So the comment that Lord Justice Laws makes at one point that the court could not assist, that if the court could not assist the airport by giving the remedy it did, then it would be powerless. That's obviously to correct a proved wrongdoing. That's wrong in my submission, because the question is not a lack of power in the court, it's the lack of the right plaintiff, the lack of the right claimant. But the National Trust instead granted a licence for occupation of the land by the airport for a limited purpose, namely carrying out these forestry activities, and left it to that licensee to proceed. Now, the authority that was granted to the airport was to fell trees, which the airport could not conveniently or safely do without first removing the people sitting in the trees. And so the court said it would give possession because that was what in practice the airport needed to be able to exercise its licence. That's the principle that your lordship extracted from the case in the Vehicle Control Services case, which is Bundle 2, tab 26, paragraph 34.
Do you want us to look at that?
Yes, let's turn that one up if it's possible to have them both open at the same time.
By having both?
I think we may...
Sorry. And that's bundle 2.
Bundle 2, it's tab 26.
Thank you.
438.
Thank you.
Thank you, my lady. And your lordship's pithy digest is at paragraph 34. In my judgment, the two principles that emerge from the case are: one, the court has power, and I emphasise power, to grant a remedy to a licensee which will protect but not exceed his legal rights granted by the licence, and I emphasise but not exceed. And then, too, in elucidation of that, the question must be, what is the reach of the right, whether it is shown the defendant's acts violate its enjoyment.
I'm so sorry, excuse me.
And I think your lordship's observations in that case were strictly speaking obiter, but I respectfully adopt your lordship's distillation. And Lord Justice Laws treats it as a case about remedies which the court can grant. Going back to Manchester Airport, page 150 of the report at D, 288 in the bundle. halfway down the page, in this whole debate as regard the law of remedies, in the end I see no significance as a matter of principle in any distinction drawn between a plaintiff whose right to occupy the land arises from title and one whose right only arises from contract. So it's about the law of remedies according to Lord Justice Laws. And Lord Justice Davis, in his supporting judgment at page 150H, starting further down that page, treats it as all about the construction of Order 113.
Sorry, who does?
Lord Justice Kennedy.
Lord
Oh,
Justice
sorry.
Kennedy.
Yes, I don't know why I said Davis. Lord Justice Kennedy treats it as being a case about the interpretation of Order 113. Those treatments may arguably be something of a fudge, because as Lord Justice Chadwick in his dissenting judgment pointed out, the order is procedural and can't create new causes of action when none existed, but it's not a fudge that causes problems for me. Because what these points confirm is that the case of Dutton is about what the court can do in its discretion to assist a licensee. The case says nothing about a licensee taking matters into its own hands, which can only be based, I say, on an entitlement to possession as of right. And the majority of the court in Dutton draw a distinction between the old action for ejectment, which depended on title, on the one hand, and the court's power to grant remedies up to and including possession to assist those who don't have title. But for a landowner forcibly to re-enter without an order, I suggest title is necessary. And if it were not so, it would be a recipe for chaos. So when will a court grant an order for possession, evicting those who are present? And looking at the cases that are digested by your lordship in the vehicle control systems case, an answer emerges in my submission. Quite clearly, in the VCS case itself, my lord, the contract expressly gave the licensee a right to evict trespassers by towing their cars away. In the Alamo and Meredith case, the tenant, Alamo, was given the express right to evict subtenants after the termination of Alamo's tenancy. So we can put these express right to evict others on the owner's behalf cases to one side. In Dutton, the airport could not safely carry out the forestry activities without excluding all others, whether they be protesters or dog walkers. In Monsanto, which was the case about GM crops and the protesters interfering with that, the plaintiff's license over the field gave it the right to do all the farming activities on the field and to take the crops. In Countryside, the claim failed because the claimant only had a right of access to carry out surveys and the like. Looking at paragraph 41 of your lordship's judgment, when your lordship comments on Countryside, page 440 in the bundle.
Sorry, I put it away. I'll just get it out.
I'm so sorry, my lord, but I don't know that your lordship needs to get it out because
Tab 26.
yes.
Yeah.
Your lordship comments on the Countryside case at paragraph 41. You say what was an issue was simply the form of action. Countryside does not, in my judgment, stand for the proposition that a licensee whose rights are interfered with is without a remedy against the person who interferes with them. So it's that point about the extent of the right granted and no further. You won't grant a right of possession in the Countryside case because that's not what the licensee contracted for. And the test that is suggested in the Countryside case, looking at the second line on this page, is one that commends itself, my lord. It says, it seems to me that there is a clear difference between a license granted for the purpose of access, which does not provide effective control over the land, and a license to occupy, which does. So I would suggest a test of effective control as being necessary before the court would grant a Dutton remedy consisting of a possession order. So Dutton shouldn't be understood as saying any licensee with a right to enter has a right to possession in the old-fashioned formal sense. A licensee can come to court and ask for a suitable remedy to vindicate its rights and no more, and the court won't go beyond that. And here, as I've said, the license was not exclusive. Chedington could not have complained if Mr. Swift had put any number of other people in the property.
But wait a minute. I mean, I know you say that this is all irrelevant because this is all about what the court can do.
Yeah.
And we never get as far as Dutton. Understand that. But if the principle is that the court will grant the licensee a remedy which will protect but not exceed the rights granted to him under the license, Chedington would surely say, we have been granted the non-exclusive right to occupy this cottage. We cannot exercise that right while the breaks claim to have exclusive occupation or possession of it. Although we might not be able to complain if Mr. Swift authorised other people to occupy the cottage with us, he has not in fact authorised the breaks to do so, and therefore the court should grant us a remedy to expel the breaks so that we can enjoy our licence.
Well, I say first that it's for Mr. Swift to say who he has and has not licensed. It's his right.
Well, the judge found that. The judge found that Mr. Swift had not licensed the breaks.
My point is that it's Mr. Swift's cause of action to expel someone who he hasn't licensed.
Well,
it's not someone with an exclusive.
You say that, but then as you rightly said, the National Trust should have been the claimants in the airport case, but they weren't. So if you substitute Chedington for the airport, Chedington say, we've got a licence for non-exclusive occupation of this cottage. We can't exercise that right because the breaks are there. They have not been authorised by Mr. Swift. Therefore, court, expel the breaks so that we can enjoy the rights granted to us by our licence. Now, I appreciate you say we don't get that far.
Yeah, we don't get that
but
far.
If we are looking at
yes,
Dutton and what you commend as the short statement of principle in VCS, I don't see why it doesn't apply on the facts of this case.
My point about that is the nature of the licence granted, that it is expressly non-exclusive. Any number of other people could be put there. So Chedington doesn't get to say...
No respect, it is non-exclusive in the sense that Mr. Swift can put other people there, not that any old Joe can turn up.
My point is that the court will only grant a remedy sufficient to enforce the rights that have been contracted for.
Well, right, well, that's exactly it. The rights being contracted for is a non-exclusive enjoyment of the cottage, which Chedington cannot implement while the breaks are there.
Well, who is to say that they cannot enjoy it? You might say they cannot enjoy occupation of the cottage as a residence if Mr. Swift puts a family of Ukrainian refugees in the cottage. Yet he could not complain, Chedington could not complain if that's what Mr. Swift decided to do. So it's a very flimsy right indeed under this non-exclusive licence. It's expressly a very flimsy right indeed. And as I say, your Lordship gets the point, of course.
Yeah.
Dutton doesn't mean the airport could have kicked the protesters out without a court order. But Chedington doesn't ask the court for a remedy. It didn't sue, it just re-entered. And it didn't merely enter, it excluded the breaks and everyone else. It put security guards on the door who were not prepared to share their occupation with anyone. And of course, all these cases under Dutton concern the legal owner granting a licence. They say nothing about a beneficial owner granting a licence. So my learned friend Mr. Colclough is right to say in his skeleton argument that this case, on the respondent's argument, would involve an extension to Dutton. And given the criticisms that have been made of Dutton and your Lordship's defence and distillation of it, or defence of the distilled version of it, it would, in my submission, be wrong to extend it to this new situation of a licence by a beneficiary. And when one puts those two inferior statuses on top of each other, the beneficiary not a legal owner, the licensee not someone with a title, one can see that Chedington's position becomes an impossible one in my submission. As we've said, a beneficiary under a bare trust who is not already in possession has no title at all. Therefore, it cannot license to the beneficiary a right it does not have. Sorry, the beneficiary cannot license to another a right it does not have. So the letter that we were looking at is essentially a nullity. Third, even if it could, the conventional position is that a licensee has no right against third parties. And there's no authority that the licensee of a beneficiary can bring a Dutton claim. Fourthly, it didn't even bring a claim. And fifthly, if it had brought a claim, I say, and this is perhaps where your lordship and I depart from each other, no remedy would be given against the family because the respondent hadn't contracted for any rights which the family was infringing. So, to conclude, there was a right way for Chedington and the Guy parties to approach this case, and there was a wrong way. They knew what the right way was because they contracted for Mr. Swift to take steps to obtain a clean legal title. That was written into the contract of sale, which he could have done. But he didn't do that, and Chedington would not wait. They chose the wrong way, which was to drill out the locks on the strength of a mere licence. And the judge records that the licence was not even part of Plan B. Plan B being the liquidator selling the rights to the property to the trustee in bankruptcy, trustee in bankruptcy selling it on to Chedington. The licence is an afterthought. And my learned friends in their skeleton complain that if we're right, it puts an intolerable burden on trustees in bankruptcy to have to go to court to get possession of bankrupt's properties. Well, forgive me, but unless trustees in bankruptcy have become a great deal more aggressive in the short period since I used to do work on behalf of trustees in bankruptcy in the county court, that is what they do. They go to court and they get orders. And that's what they should do. So it doesn't impose any intolerable burden on a trustee in bankruptcy. I think I'm just about on schedule, my lord. I'll move on, if I may, to the 1977 Act point, unless your lordships have any further questions on the first ground of appeal.
No, thank you very much.
Can we look at the version in the supplemental bundle of authorities, please? Because that's a fuller copy of the Act, Act 1. Turning to section 3, which is the section with which we're concerned in this case, and unusually starting at subsection 2b, it's page 5 of the bundle. It says subsection 1 applies to a license for occupation as a dwelling other than an excluded license. Section 3A, subsection 7, is the relevant species of excluded license for today's purposes. A couple of pages on, page 8. A tenancy or license is excluded if A, it confers on the tenant or license the right to occupy the premises for a holiday only, we're not interested in that, or B, it is granted otherwise than for money or money's worth. So gratuitous licenses are excluded. So if it's a license but it's not an excluded license, then section 3.1 applies. So turning back to section 3, subsection 1, reading it mutatis mutandis, applying to a license, where any premises have been licensed as a dwelling under a license which is not an excluded license, and A, the license, has come to an end, that's not in dispute, but the occupier continues to reside in the premises or part of them, it shall not be lawful for the owner to enforce against the occupier otherwise than by proceedings in this court his right to recover possession of the premises. And occupier under subsection 2 means the person lawfully residing in the premises or part of them at the termination of the former license. And we can see what owner means in section 8, on page 14 of the bundle. In part 1 of this act, the owner in relation to any premises means the person who, as against the occupier, is entitled to possession thereof. That's why I said at the outset that these are true alternatives. If Chedington win on ground 1, and therefore they are entitled to possession as against the occupier, that's what triggers the act. Because if it wasn't if the owner didn't have the right to occupy, then the protection of the act would not be needed. As we've observed, the section doesn't create its own cause of action. It just deprives the evicting party of its defence based on the right to possession. So the evicted party has a claim for damages despite the owner's better title. So to summarise, we have to show there was a licence to reside in the premises. That's disputed as to whether there was a licence. That it was granted for money or money's worth. That's disputed on the basis that it says rent-free. It must have terminated at the time of the eviction. That's not disputed. The eviction was done by the owner. That's, I think, no longer disputed. My learned friend and I have exchanged words about paragraph 22 of his skeleton argument, which says we are not the owner, but I think they now concede that on their case they are the owner. And that someone, the family, or at least one member of the family in this case, the occupier, was lawfully residing in the premises or part of them at the time of the tenancy licence's termination. That's a new point from the respondent's notice, which is disputed as to the cottage, but not disputed as to the house. And that finally, that someone or those someones, the occupier, was residing in the premises or part of them at the date of the eviction. And that is, again, disputed as regards the cottage, but not as the house. And it's in relation to these last 2 points that the new point I mentioned an hour and a bit ago comes in. And I had, your lordships would probably guess what it is, and indeed I wouldn't be surprised if my learned friends have been waiting to see when I was going to wake up to the point. And the point is this: the premises under the licence are the whole of the farm, including the cottage. And it is not in dispute that the family were residing in the house at the date of eviction. Indeed, that is why they say they were not residing in the cottage. The other side said the family was not residing in the cottage. Therefore, the residence requirements are satisfied. It's not in dispute on the obvious interpretation of section 3, subsections 1b and 2. Now, my learned friend says it's too late for me to raise this point. And it's perhaps a little embarrassing that it didn't occur to us sooner, given that it's there on the face of the statute, but it is just a straightforward point of law. And it's, you know, perhaps our attention was distracted by the myriad other points that were being taken on this act. So I apologise for that, and I apologise for putting my learned friend in difficulty by not raising it in the skeleton argument earlier. But as your lordship can see, it's a very straightforward point. And if it's right, it obviates the need to go into all these factual questions about whether or not they were residing within the meaning of the Act in the cottage, as the judge found they were not. So, my lord,
I'm sorry, I'm being very stupid, Mr. Limar. The point goes, you're saying that the licence covered the whole of the farm.
Yeah.
But when you go back to the licence, it's talking about the property.
Yes.
And the property is defined as the cottage.
Yeah, that's the wrong license.
I've got the wrong licence. Thank you. Thank you.
It's the partner.
That's the.
Yeah.
Yes. So we're looking at page 10 of the supplemental bundle, paragraph 8.4. The partners hereby agree that the founding partners are entitled to reside in the premises as licensees. Next paragraph. West Axnoller Cottage forms part of the premises.
Thank you.
So that's the point, and it's such a simple one. We're kicking ourselves for not thinking of it before yesterday evening, but it's one of those things, I'm afraid. So I will sit down for a moment to let my learned friend advance his arguments as to why we shouldn't be allowed to raise it.
Yes, Mr. Suckling.
My lord, in the interest of time, I suggest the court hears this point, and I'll deal with this in response.
All right.
It's a bad point, but I can deal with this in response.
All right.
Well, that was easier than I expected, my lord. So that's the point on that, and I won't have to say much more about it.
Well, you've made it. I mean, that's the point, isn't it?
Yeah, indeed.
You look at the partnership deed, premises are widely defined. It expressly says that the cottage is part of the premises. Clause 8, whatever it is, 8.2, gives the founding partners the right to reside, and therefore the cottage is part of the premises.
Well, not only that, you also rely on the factual finding that they were in residence at the house.
Yes, it's not contested by the other side. They say we weren't in residence in the cottage because we were residing in the house.
Yes, and you say that it's enough that you're in residence of part of the premises comprised in the licence, and you were, if it's the house, therefore it was unlawful to do what? Just go back to the...
Therefore, it was unlawful to enforce against the occupier, otherwise than proceedings in the court, his right to recover possession of the premises. And in fact, there is case law that clarifies that means recover possession of the premises or part of them.
Well, exactly. You've got to read the last bit of section 3.1 as including part of the premises.
Yes, I mean, there is authority to that effect. There's cases, for example, on licences of shops with a flat above. The tenant of the licensee is only residing in the flat above, but that doesn't allow the licensor even to retake possession of the shop part. So, who is the owner? I think we've established that the owner, on the hypothesis that we've lost on ground one, is Chedington, because it's the person with the right to possession. That doesn't involve any concession on my part. It's only if contrary to my submission.
Of course.
First argument in relation to licence is the argument of the judges that the licence was not a licence, or a tenancy for that matter, within the meaning of the 1977 Act, despite the fact that the partnership agreement said in terms that they could reside there as licensees. And the reason that the learned judge says that isn't a licence, one of the reasons the learned judge says that isn't a licence is one can't grant myself a licence. And that's not put as a point on the two-party rule in the strict sense, at least not in terms, and rightly so in my submission, but it's instructive to see why the two-party rule doesn't apply. Obviously, if the two sides to a contract on both sides are identical, then that's a nonsense and the two-party rule applies. But if the parties on one side of a contract merely overlap with those on the other side of the contract, then in general terms there can be a contract. Stricter rules were developed at common law in relation to covenants under tenancies, and that's a point that your lordship would have dealt with in the Proctor case, and the Proctor case is referred to by the learned judge in his judgment. But those stricter rules were then resolved by statute. And also the point that comes up in the Proctor case is if the parties on one side of the contract were acting in a different capacity to those on the other side of the contract, then they can contract with each other. And that happens all the time. So trustees can, in theory, grant a lease or a license to one of their number. And that would be self-dealing, of course, but then the terms of the trust could permit self-dealing. And if there were a problem with the two-party rule, that the breaks can't license something to themselves, then the solution would be obvious. You would interpret the license, not as a license by all three partners to the two founding partners who get the breaks, but as a license by the other partner, Hatley Wood LLP, to the two founding partners. Because it's Hatley Wood who would otherwise have the right to complain. So that's the converse of the situation in the Harrison-Broadley case. The reason the license was not allowed in the Harrison-Broadley case is not because there was the same person on each side of the contract, but because on the interpretation of the contract, which was a rather obscure document, I think Lord Justice Harman describes it as witchcraft, on one interpretation it was purporting to grant possession to the widow who already had a right to exclusive possession under the terms of a family arrangement. The point was not that it couldn't be the same person on both sides, so much as it couldn't be read as granting her a right she already had. Therefore, it ought to be interpreted as her granting a right to share possession with her to the farmer, the contract farmer in effect. And shared possession was not enough to give the farmer protection under the Agricultural Holdings Act, and that was the ratio of the case. On the basis of that judgment, the respondent, and I think the learned judge, says that clause 8.4 of the partnership agreement can't amount to a licence because residing in the premises by the founding partners would not be a trespass, but would be a different kind of wrong, a breach of their duties as partners. But in my submission, the nature of the wrong that would otherwise be committed does not matter. The definition of licence is not as narrow as the judge puts it at paragraph 130 of his judgment. And is the same way that the learned friends put in their skeleton argument, which is, one moment, sorry. A licence is a permission which prevents the act of entering or remaining on the land from being a trespass. But the word trespass is not found in the definition of licence in Jowett dictionary. It's not found in the definition of licence in the Stroud's judicial dictionary either. I've got copies of those I can hand up if it were necessary to do so.
Well, we go all the way back to something in Vaughan, don't we, in the 1600s. I can't remember the name of the case now.
I'm not sure I've got that
Which
far, my lord.
is the classic definition of licence. I can't remember it now.
Well,
It's in the bundle. It's in the bundle. Thomas and Son.
Thomas.
Thomas and Vaughan, is it? Is that it?
Thomas and Sorrell. It was
Sorrell.
Chief Justice Vaughan.
Ah, that's where the Vaughan came from. Yes, sorry, misremembered. You say we've got it in the bundle?
Yes, you have. I think tab 4 of Authorities 1. And the relevant passage is page 23.
Page 20.
23 between the whole thing.
Yes, thank you. A dispensation or a licence properly passeth no interest, nor alters or transfers property in anything, but only makes an action lawful, which without it had been unlawful.
Yeah, so you say that even if you go back to that, it's not restricted to trespass.
It's not restricted to trespass.
Anything which would have been unlawful becomes lawful.
Jowett says defines it as a permission given by one person to do another to do some act which without such permission would be unlawful or legally ineffective. And Stroud says refers to Chief Justice Latham in a Commonwealth case, Federal Commission of Taxation. It says a licence is an authority to do something which would otherwise be wrongful or illegal or inoperative. So what sort of wrong it would be?
Hence the example you gave earlier of licences of intellectual property rights, as just one example.
What sort of wrong it would be, of course, depends on what it is one is being permitted to do and the existing relationship between the parties. No doubt in relation to land, the most common wrong that would be committed in the absence of a licence is a trespass, but that's not the only one. And as my learned friend says, Thomas and Sorrell doesn't give that definition. And if the parties are in a different relationship, they're not just third parties, they're not strangers, then it may be a different sort of wrong that the licence permits, but it's nevertheless a licence in the common sense definition of the word. And the judge himself says that it would be a breach of duty for a partner to use partnership property for personal purposes, giving rise to a duty to account. Indeed it would. And so as he rightly says, clause 8.4 is a relaxing of a rule about breach of fiduciary duty, or to put it another way, it is a permission to do something which the family is not otherwise entitled to do. That's what a licence is. A permission, that's literally what it means. Is there any reason to interpret licence more restrictively in the context of the 1977 Act? In my submission, no. There's no limitation put on the word in the Act. besides that it must be a licence to occupy premises as a dwelling. So it's defined by what it permits, not arbitrarily by the nature of the wrong that would otherwise be committed. The policy of the Act, as I say, is to protect people who were once lawfully in possession from eviction without a court order. And Section 3 of the Act is very careful and specific about the nature of the licences and tenancies that are excluded from the ambit of the Act. There's no reason to think that Parliament had in mind any more restrictive definition. And just to sort of finalise this point, Malone Jr. points out in his main skeleton argument, the judge himself had previously described the family's right as a licence in his 2020 judgment. So the judge himself said it was a licence, but has now resiled from that in this different context. The next point is whether it's an excluded licence. And it's a point in its pure form which the learned judge rightly rejected, but is reinstated by Malone friends in their respondent's notice. The respondent says that because paragraph 8.4 says the licence is rent-free, therefore it is an excluded licence under section 3A7, because that section excludes licences not for money or money's worth. But those last three words immediately falsify the point that's being made. They only have to be stated to show up the flaw. The point about section 3A7 is to exclude an entirely gratuitous tenancy or licence, but rent is not the only way of paying. Service is rendered with due. The judge demonstrates that himself, citing the Polar Park case, a decision of Mr. Justice Briggs, where Mr. Justice Briggs is talking about a licence granted by a trustee to a discretionary beneficiary, rent-free, but on terms that the beneficiary pay the insurance and keep it in good repair. And that was consideration enough. That was money's worth enough for it not to be excluded under section 3A. So when my learned friend says in paragraph 20 of his skeleton argument, the policy of the Act is to protect those who pay their landlords, that's not what the Act says. And given the words used, it can't be inferred. In fact, the policy of the Act is to protect, in the limited way that the Act does, to protect even tenants who don't pay their landlords. Most applications to court for orders for possession that need to be made because of this Act are being made because the tenant hasn't paid. That's what the Act's for. So it's about whether the licence was gratuitous in its form, not whether the tenant is actually paying. And the licence is granted in the part of the partnership agreement that deals with drawings, and the respondent points out that very fact in the context of his argument that there's no licence at all, but that rather undermines the point that it's not for money or money's worth. The family's been granted the right to live in the house and the cottage as part of its profits from the partnership. So we agree with what the judge says on this point in paragraph 184 at page 99.
So you say it's part of its profits? Part of their profits. So are they...
Part of its drawings. Part of the reward it takes from its efforts in the partnership.
They're not... They don't have to deduct the rental value from what would otherwise be their share of profits.
Exactly. So page 99 of the main bundle, paragraph 184, the learned judge says this and is absolutely right. Chedington points to the words rent-free in clause 8.4 and says that any such licence could only have been a bare licence. I disagree.
I beg your pardon, could you give me the paragraph reference?
Sorry, my lord. It's 184 on page 99.
Thank you.
If there had been any such licence granted by virtue of clause 8.4, then it would have been part and parcel of the whole commercial arrangement between the partners with consideration on all sides. It would not have been a bare licence at all. The words rent-free merely serve to show there was to be no setting off of the benefit against the drawings of the Briggs. So that first point falls away in my submission for the reasons the judge gave. But then, in paragraph 187, the judge essentially contradicts himself, and that's where the learned judge and I part company. He's just found that it was part and parcel of a whole commercial package with consideration on all sides, i.e. money's worth. But then he says in 187 that the break's contribution, the consideration, had nothing to do with the property itself or its condition. Where does that come from? That's not in the Act. The judge cites no authority for it at all. With respect, rent has nothing to do with the property or its condition, just the fact that it is given in consideration. It is a quid pro quo, and the judge has just found that there is a quid pro quo. Now, as I say, the judge cites no authority for that strange proposition.
So
at
you
all.
effectively say 187 contradicts what he's just said in 184.
Does, doesn't it? That's my submission. Now, to try and justify this bit of judicial creativity, my learned friends have found the case of West Wiltshire and Snellgrove, which is the first bundle of tab 17. I won't take your lordships to it. I don't think I need to, but I can explain why it's not going to assist my learned friend. And it's this. There's two reasons. The first is that the reasoning and the result of the case are completely wrong. And the second is that the facts are completely different. As to the reason it's completely wrong, is that it was a prosecution in the Magistrates' Court under Section 1. What had happened is Miss Snellgrove, Rachel Snellgrove, had moved out of her house and into her parents' house. And a family friend, Mr. Lacey, had asked to live in her house for the duration of her moving out. And she had said yes, and he agreed to pay £10 by way of reimbursement for his use of the utilities and the food that was in the fridge. And after a time, the Snellgroves asked him to move back out, and he didn't. And the Snellgroves went in, and there was a confrontation, and they were charged with an offence under Section 1. And Mr. Justice Curtis held that and indeed Lord Justice Simon Brown, on an appeal by way of case stated, held they'd not committed an offence because it was an excluded licence, because the money that was paid, £10, was not paid in exchange for possession of the property. The problem with his reasoning is that Section 1 applies to tenants and licences whose licences continue in force. Section 1 has no reference to excluded licences at all. Section 3A, which defines excluded licences, says, where in this Act you see the words excluded licence, this is what it means. We don't see the words excluded licence anywhere in Section 1. So with respect to the Divisional Court, they fail to appreciate that Section 3A only excludes licences from the ambit of Section 3, not from Section 1. And so the court was simply wrong to find for the Snellgroves on that point, however sympathetic they may have been to them. In fairness to their lordships and to the learned friends, Mr. Justice Briggs doesn't appear to have spotted that point in the Polar Park case where it was cited to him. So, first point is that Snellgrove is not good authority for anything, it's just obviously wrong. But secondly, in any case, the facts were very different. It was an informal arrangement, nothing in writing. The fact that there was no quid pro, the finding was that there was no quid pro quo for the occupation of the property, and the money that was changing hands was to do with using the utilities. Not insurance, not keeping it in repair, not rent, nothing else. And that's not this case at all, because as the judge has found, the parties' respective responsibilities are set out in a written partnership agreement, part and parcel of the whole commercial package. So it's frankly heresy for my learned friends to try and prize apart the constituent elements of the consideration in this commercial package, to say there's consideration on all sides, but on one hand, but not apparently for the occupation of the cottage, which is gratuitous. Doesn't make any sense. So that rather comprehensively deals with that point, I hope. The next part of the learned judge's reasoning, in case he was wrong on that, is to say in paragraph 188, he suggests that if it wasn't an excluded licence when it started, it became an excluded licence once the partnership was resolved, on the basis that once the partnership was resolved, there was no consideration moving to the partnership. because the quid pro quo could no longer benefit the licensor. Again, no authority is cited for this novel proposition, and even my learned friends in paragraph 26 of their skeleton are pretty muted in their endorsement of it, and clearly haven't been able to find any authority to make it make sense either. It's hard to know where to begin with that as an argument, because there's nothing in the 1977 Act to suggest that a licence or a tenancy can change from being non-excluded to being excluded during the course of the licence. On the contrary,
Why not?
well, the Act defines an excluded licence by reference to the terms on
Of the
which it is
grant.
granted. At the outset, if there were a variation by agreement, for example, so that no consideration was being provided, then probably that variation would be unenforceable unless it was a specialty. But then, I guess, the variation would be treated as a new licence.
Yeah. Have in mind somewhere the judge found that during Serafina's time, all the expenses of staying in the cottage were paid by Serafina on the basis that Mr. Brake was there in order to support the wedding business, but I can't at the moment locate that finding.
Perhaps I can ask my learned junior to have a think about your lordship's point. But also, the point is that in the 1977 Act, there's nothing to say that the excluded licence has to remain in force at the relevant time. On the contrary, the licence has to have come to an end for the Act to apply at all.
Yes.
It's enough, under the Act, reading the words, that there was once a non-excluded licence. And on this hypothesis, there was. So it's not just that the licence or the definition of excluded licence is by reference to the terms of the grant, but also that the protection applies where it was once let under a licence. You see, there's two related allied
I
points
don't
there.
find that point an easy one. I mean, let us suppose that there had been a tenancy granted, contractual term which came to an end, under which a rent was payable,
Mm-hmm.
and the former landlord and the former tenant agree that the tenant can stay on paying nothing. Would that not
Yes.
be an excluded licence? You say you can go back, what, into the mists of history to find out that there was once something which was neither an excluded tenancy nor an excluded licence? I find that not easy.
Where any premises have been let as a dwelling under a tenancy, which is not an excluded tenancy, and the tenancy has come to an end, but the occupier continues to reside in the premises, it shall not be lawful for the owner to enforce
So
against
you
the
say
occupier.
yes, as a matter of plain English you can.
I'm afraid so. Well, I'm not afraid so. I'm glad that it's so, but the Lordship gets the point. And there's nothing in the 1977 Act to say that a licensee must actually be performing its agreement to provide consideration in money or money's worth. On the contrary, as I say, the Act normally applies when the tenant has stopped performing. So the judge is quite wrong, again, to say that the policy behind Section 3 is to protect those who pay their landlords. The reasoning in the second half of paragraph 188 discusses whether, put it down there, discusses whether there are two possibilities, he says. Either one, the entire consideration for the licence was provided up front, and so it continues not to be excluded. Sorry, either the licence becomes excluded at the time, in other words, the time when the partnership no longer benefits from the consideration, or two, it never does, because the entire consideration for the licence was provided up front, and so it continues not to be excluded in perpetuity. And that appears to be premised on the idea that if the tenant stops paying, he loses the protection of the Act. But that's about as wrong as it's possible to get in the context of the 1977 Act. There's nothing in the 1977 Act to say that the consideration has to be beneficial to the licensor. Money or money's worth does not imply a benefit to. That's not the way consideration works, as we know. If A and B agree to swap 10 of A's apples for 10 of B's bananas every month, it's still a contract, even if B is allergic to bananas, and even if B becomes allergic to bananas halfway through the contract.
Well, perhaps more to the point, A and B can have a contract under which B agrees to pay something to C. That's
Well,
the
now we're
consideration.
getting into the 99 Act, aren't we? But
No, it's a contract without any Acts of Parliament.
Yes.
It's a contract.
yes, but it's not enforceable by C.
Yeah.
Yeah, but your point is that it doesn't have to benefit B.
No, exactly.
So
And so on that basis, the last line of 188 must be wrong.
yes, I consider the license becomes an excluded license once the consideration can no longer benefit the landlord. But that's not what the Act says, and it's not a conventional interpretation of contract law.
No.
I moved through those various grounds quite rapidly, but I hope that's satisfactory. When we turn to the last issue, that of residence, there are two arguments here, one of which was considered by the judge, the other's been raised in the respondent's notice. The one that was considered by the judge is whether the breaks were in residence at the time they were evicted, and the judge made findings about that, albeit that he didn't direct himself by reference to any case law. But the new point that is in the respondent's notice is about whether or not the breaks were in residence at the time the licence came to an end. And that's problematic because the judge didn't consider that question, wasn't asked to consider that question, and made no express findings in relation to it. And it's not just a case of were they or were they not in residence. It's a question of when we're looking at, because the judge didn't make any findings as to when the licence came to an end, save to say that it had come to an end if on the 15th of January, if not before, at the latest on the 15th of January 2019. And this is a very complex question because, well, there are cases, there's one in the bundle, the Lion Moheel case, about when a licence comes to an end on the dissolution of a partnership. Does it come to an end on the dissolution? Does it come to an end on the administration order? Does it come to an end on the liquidation? Or does it only come to an end when the premises are transferred by the legal owner, the licensor, to another third party? So those are all possibilities, and it's a difficult question of law, not one the court addressed. And therefore, one simply doesn't know what time one is looking at when it comes to deciding whether or not the breaks were in residence under this head. If it was only on the 15th of January 2019, 8 days before the eviction, then it probably makes no difference at all because the time period is so small, in which case why bother raising this as a separate head. If it was much earlier, then the factual scenario may be entirely different. Indeed, between 2015 and 2016, it's common ground that the breaks lived almost exclusively in the cottage. So I say, in relation to that new reason under the respondent's notice, that it's too late to raise it, not because it's an interesting legal point, but because we just don't have the factual material from which to judge it. If it had been run like that, then submissions would have been addressed to the question of when the licence ended, findings would have been made, and submissions would have been made to the factual scenario on the ground at that time, whenever it might have been, and evidence would have been addressed to that. Yeah. There's an analogy here with my Lady Justice Asplin's recent decision in the Hughes and Pritchard case on testamentary capacity, where the appellants tried to raise the Parker and Felgate case, and your Lordship's familiar with Parker and Felgate, having sat in Perrins and Holland, and it was sought to argue on appeal that the testator had capacity when he gave instructions, even if he didn't have capacity when he signed the will. And my Lady said, well, it's too late to raise that on appeal because it would have involved different evidence and different submissions. So that's the analogous situation. In my submission, that ought not to be raised. But if it is raised, and we take the date as the 15th of January 2019, then it adds almost nothing. So that then leaves the point that I just was making, as your Lordship said, I've already made. Residence in the house actually satisfies the residence conditions. We don't need to look at residence in the cottage. don't know what else I can add to that. Maybe I don't have a preview of what my learned friend's response to that is.
No.
And I will do my best to reply. On the hypothesis that I don't win on that point, then nonetheless we need to address that factual point about
Residents in the cottage.
residents in the
Yes.
cottage. And at this point I will hand over to my learned friend, Mr. Colclough, to address your
Yeah.
questions on that.
In answer to my Lord's question, the paragraph of the judgment was in relation to Sarafina, their later AEL paying expenses. It's paragraph 48.
48.
To page 58 of the
Yes, thank you. I did remember it somewhere. Yes.
My Lords, my Lady, if I can just start by setting the scene for the small bit of the case that I'm arguing. We only get...
So just hold on a minute.
Sorry.
So by this point, the partnership had been dissolved. And Sarafina AEL were paying the Breaks living expenses on the basis that they were staying there to further the wedding and events business.
Yeah, so Sarafina stroke AEL owns the house, but not the cottage at this point.
Right. Yeah. Thank you very much.
And, my Lord, if I may, just to show you how the respondent puts its case, page 168 of the core bundle. If the question is, was there some sort of intervening license?
Right, I'm afraid I've only got the internal pagination on this one. So what page? This is their
It's the
replacement skeleton,
replacement skeleton,
paragraph
paragraph 27.
27. Thank you.
The respondent puts their case that the licence terminates on the 15th of January 2019. So that's the respondent's case on termination of the licence.
Yeah.
The interesting factual question that might have arisen at trial but didn't. So if I can just start by setting the scene in terms of my bit of residency that I'm arguing, and we only get here if what Mr. Laymoth has described as the new argument
Fails.
It fails. Yeah. Because then we have to ask where was the family in residence of the cottage alone
Yes.
as at the 18th of January 2019. Although it was an issue below, it is now undisputed that the family had both physical possession of the cottage and intention to possess up to and including the date of eviction. And as we have seen, the partnership agreement used the words license, reside and premises defined as including both the cottage and the house as a unitary premises. The judge found that in 2015 and 2016 the family primarily lived in the cottage. That's paragraph 46 of the judgment. And nobody has ever suggested that they were not in residence at that point. So the question is, or was, or should have been, when did the family stop residing in the cottage? On the assumption, of course, they were not simply residing in the premises, which is now the appellant's primary case. If we have a look at the judgment, we can see what the judge's conclusions were in two paragraphs only. So the first is paragraph 50 of the judgment.
50.
50.
Yeah.
At the bottom of the page, just 2 lines. After Mr. and Mrs. Brake were dismissed from their employment on the 8th of November 2018, they stayed overnight exclusively at the house. Mrs. Brake's son, Tom, did stay overnight at the cottage on several occasions during this time, but eventually that ceased too. And he then goes on to set out a variety of factual matters which arise between the 8th of November 2018 and the 18th of January 2019, which is the date of eviction. So the focus in this paragraph is entirely on what happened between those two dates. And then his conclusion on the issue is at paragraph 189.
Yeah.
There's a further point. Section 3 requires that the occupiers of the property must reside in the property. I've no doubt that a person may reside in more than one property simultaneously, but I've found there's a fact, which must be a reference back to his finding in paragraph 50, because nowhere else does he deal with the issue, that the Brakes and Tom had ceased to reside at the cottage before the 18th of January. In my judgment, therefore, section 3 does not apply. So that is, we say, a finding that there was a loss of residency between the termination of employment at the start of November and the date of eviction on the 18th of January. And in fact, the respondent reads the judgment in the same way. In paragraph 29 of the replacement skeleton argument, in particular after the Brakes, sorry, if I can just start at paragraph 28 in fact, the judge found as a fact that Brakes were not residing in the cottage, and then refers to the only two paragraphs of the judgment where he made that finding, 50 and 189. And then paragraph 29 sets out the reasons in support, which are all based on matters that happened between the 8th of November 2018 and the 18th of January 2019. So we're all agreed, I think, that what the learned judge found was that something happened of a sufficient quality in that 2-month period that caused the loss of the family's residency in the cottage for the purposes of the 1977 Act. We say that is not a finding as a matter of proper legal evaluation that was open to him on the authorities. And if I can just briefly explain why we say the judge went wrong. The court will have seen the judge did not attempt to define residency at any point in his judgment and did not refer to any authority on the question. Now, partly that was not his fault, it was the way that the case was argued before him. And if I can show the court the supplemental bundle, please, not the supplemental authority, it's the supplemental bundle. Page, in my version, it sounds like maybe we're slightly different versions, it's page 266.
Claimants reply submissions.
Yes. So this is a document entitled Chedington's reply. Sorry, have you got the claimant's reply?
I've got a document called Claimants Reply Submissions.
261, I've got Chedington's.
So 261 on the pagination of the report.
261 you want? 261, yes? That's Chedington's claims. That's what I'm supposed to be looking at. Is
Yes, yes. I'm glad we got there. So these are the reply closing submissions. There was nothing about residency in the opening submissions. There was nothing about residency in Chedington's closing submissions. It emerged for the first time in reply closing submissions. And it emerges at the bottom of that page, 261, the court's version, paragraph 3. Having now reviewed the Brakes closing submissions, Chedington makes 2 further points in reply, I add for the first time. 1, residence for the purposes of section 3 of the 1977 Act is a narrower concept than possession at common law. That's fine as far as it goes. And then the analysis of paragraphs 96 to 107 of Chedington's closing submissions also apply to the question of residency. That is all the judge got by way of submission. The Brakes were not even given an opportunity to make any submissions on the question of residency and didn't, because it came from the reply closing submissions. And that's why we say, respectfully, the judge went wrong. This is not a procedural irregularity point on appeal. I want to make that clear. We're arguing the merits of it, but that is why he wasn't addressed on the authorities and why he didn't in his judgment. Now, if I can turn to the authorities on what the word reside means, its ordinary legal meaning. can I start with the main authorities bundle, part 2 of the main authorities bundle, tab 28, please?
Will be in volume 2.
It's in volume 2.
Yeah.
And the internal pagination, the bundle pagination, it's
Yes.
506.
Yeah.
And it's the dissenting judgment of Lord Newburger in the London Borough Council case. And it's a helpful overview of some of the authorities that I'm going to take you to. The court might ask me, well, what does any of this mean in its context? So paragraph 108, in fact, can I just invite the court, given time constraints, invite the court to read paragraphs 108 and 109, please.
Yeah.
So 2 points here. The first, the test of residency, and we'll see this in some of the authorities, was a judge-created test. Originally, it was created by the courts and subsequently codified by Parliament in the 1968 Act, which required the courts to test the question of residency by reference to the previous decided decision. So that's the context we're in. It was originally a court-created test, and secondly, as we can see in paragraph 108. The key principle that emerges, and this is about 3 sentences in, the courts developed the rule that a tenant who was absent had to establish inward and outward manifestations of residential occupation. So that is, we say, at the heart of the test that's applied in the requirements as confirmed by Lord Newburger here. This is a dissenting judgment, but he was dissenting on slightly different points.
Yeah.
So I'm going to attempt in about 10 minutes to take the court through 7 of the main authorities on residency, including the 4 authorities that were highlighted to us last week by way of email from the Lordship's clerk. So can I start with Beck and Schultz, please?
Yes.
Which is in the supplementary bundle, tab 8.
That's the case that Lord Newburger mentioned at the end of the paragraph you showed us.
It's tab 8, supplementary bundle, page 54. The landlord of a flat in London sought possession on the grounds the statutory tenant had abandoned possession. So just to pause there, this is prior to the 1968 Act, so the court at this point is applying the common law test, the judge-created test of residency. The tenant slept there 4 or 5 times in the year, and her husband on average about once every 2 months. On appeal from the county court judge who refused an order, the true test to be applied, and then we see 2 sentences down, it was necessary to show both the mental element of the occupation as well as some physical sign of it, and it was not sufficient to show the tenant had left furniture in a caretaker and desired to retain possession because he or she occasionally found it convenient to resort to the premises. And in fact, the judge, what the court found here was simply that the judge below applied the wrong test and remitted it back to be cited again. So those are the basic facts. And then if we can just turn, please, to page 58, the Master of the Rolls judgment. He sets out that the second sentence, the case is another illustration of one of the more difficult problems, namely the problem of the so-called two-home man. The classic instance, Langford property. In that case, a Greek had a home in Buckinghamshire, had to work during the week in London. During the working week, he habitually slept at a flat in London, and obviously ordered his life in the same way, and that was found to be a residence for the purposes of the Rent Act legislation. And Master of the Rolls goes on to say this is much less of a two homes case, the case before him, than Langford, because the flat was retained as a pied à terre. On the next page it says that's ambiguous. And then about halfway down, the sentence starting, nevertheless, I cannot see it will be in accordance with the main principle and purpose of the rent restriction legislation to hold that a man may have statutory protection for any premises to which he may occasionally find it convenient to resort, and in which he may keep the evidentiary installed.
Sorry, where are you?
Sorry, halfway down the page on 59.
59.
Yes.
Yeah.
Starting, nevertheless.
Yes. I mean, this case is all about intention.
No, it's not really about very much, because what the court says is that the judge below applied the wrong test. He thought that he was bound by the Langford decision, which was a classic two homes case, and therefore it must follow. And all the court says here is, no, he wasn't bound. He hasn't properly done his job, which is to consider whether in the context of this case, the tenant was truly residing in two properties.
Well, this is a case where, as far as one can tell from the facts, which are recited at 571,
yes,
the flat was furnished and it had a caretaker in it.
yes,
So there was an outward manifestation of occupation, which is why I suggested to you this is really all about intention.
yes, and there's probably a further point as well, which my bloody friends will no doubt rely on, which is it's the quality of that occupation as well. It's not enough to just say I'm going to go and visit that property once a year, even if you have an intention to do that
Yes.
all the time. It has to be of a sufficient quality,
Yeah.
part and parcel of one's life. And the court here, although remitting it back, is saying in pure pied à terre cases, that's not of a sufficient quality.
Right, and here on the judge's findings, not only did the Brakes hate staying in the cottage, their only intention would have been to do so again if there was another wedding.
Yes.
They'd already been dismissed from the business, so the prospect of their assisting in another wedding was remained, wasn't it?
Well, I'm getting slightly ahead of myself into my submissions. As we've seen, what the judge found was that between the 8th of November and the 18th of January, the Brakes lost residency.
Yeah.
Now, that means that prior to the 8th of November, they had residency. So how were they occupying that property up until that period? Well, they were occupying it in the same way as they had throughout, which is they lived in the house during the week, and on the wedding weekend they went to the cottage. That's the pattern.
Sorry, did the judge make a finding that they were resident in the cottage before November 18?
Well, it's not expressed, but what he says in his judgment is that they ceased to reside there. And he says that they ceased to reside there by reference to what happens after the 8th of November. And that's how my learned friends put their case in the respondent's skeleton argument. Now, this is the fundamental problem with how the judge went about this, because if he'd been properly addressed on the relevant authorities, he no doubt would have been able to make a clear finding about what the position was prior to the 8th of November. We wouldn't be left in the Court of Appeal guessing what ceases to reside means. But we say the only sensible way of reading it is that they ceased to reside after the 8th of November, because they're the only factors on which it relies. And if that's right, then the judge is with us, albeit I can't really have my cake and eat it and say, well, he didn't apply the rights of authorities post 8th of November, but must have done prior to the 8th of November. But his finding must be that there was sufficient residency prior to that point, because the occupation was of a sufficient quality. And then the question becomes, well, did they have the intention to return in the 2 months in which they'd gone away, return to the state of occupation, which was fundamentally the same as it had, the state of occupation prior to the 8th of November, and they gave the undertakings to the court the day before, in which they undertook to the court that they would return to the pattern of occupation which we say, and the judge found, was sufficient for residency. In a nutshell, that is our case.
Yeah.
And there is absolutely nothing that's happened between the 8th of November and the 18th of January to remove the Brakes' right of residency. And in fact, those undertakings are absolutely critical, because because what better evidence could we have of their intention to return? There is no better evidence than that.
Yeah.
So I'm guessing ahead of myself because those are my submissions.
Right.
Can I take the court back to the authorities, please?
Yes.
Back into the main authorities bundle, because I'm doing these chronologically. Tab 11. Go for investment. We're going to reach a point, I suspect, in a moment, where the court will ask how can we possibly reconcile any of these authorities, which we have to do with some difficulty. So tab 11, main authorities bundle, will go for investments. The facts were, the tenant took a lease of a flat subject to the provisions of the Rent Act. She and her husband and 6 children lived in the flat until 1970, but then she and her husband and 4 of the children left to live abroad. Initially, the 2 eldest sons remained, but then essentially a caretaker or a licensee went in. And then if we see halfway down that paragraph, there is a sentence starting by her amended particular defence. The tenant claimed when she left the flat in 1970, she intended to return to it when her younger children completed their education in about 8 to 10 years. So this is a 2 homes case because the family move abroad, presumably into another home, and their intention to return is 8 to 10 years later.
Yeah.
And the court says that's fine. Because, see at the bottom of that page, dismissing the appeal, the tenant showed both de facto intention to return after his absence, coupled with the visible state of affairs.
Yeah.
So again, showing that the heart of this question is the heart of the issue of residency is the 2-pronged question, which looks a bit like the question of possession. Is there an intent to return, reside there at some point, and is there a sufficient outward manifestation of that internal intention?
Pretty remarkable that an intent to return within 10 years was held to be not unreasonable.
Well, quite.
But there we have it.
We do. And in our case, just by way of reminder, the absence from the cottage was 2 months in the case of Mr. and Mrs. Bragg overnight, and 1 month in the case of Tom, his son.
Yeah.
Combined with the undertakings given the day before. Tab 9 of the supplementary authorities policy.
What the court decided in Gopher was that the judge applied the right test.
Yep.
And there was evidence on which he could reach that conclusion.
Yep. In much the same way as in Beck and Schultz, the court found they'd applied the wrong test and submitted that. This is why it's difficult to discern principles from these cases, other than this 2-pronged question of internal intention combined with.
But the cases stress that it's some cases call it a jury question, some say it's a question of fact and degree, but it's essentially a question of fact for the trial judge.
It is, once the judge is aware of the relevant authorities.
Yeah.
That's the fundamental problem with the judge's analysis in this case. He wasn't. Hence, he didn't apply any test, let alone the right test. Regalia and securities is tab 9 of the supplementary bundle. The facts of this case, in a sense, this is what against us, were that the tenant moved into a property with his partner. During the winter, they rented out the house and moved back into different accommodation, but for about 2 months in the flat. So this was occupation purely during the winter. And it was found that the tenant had lost his residency in the flat. Now I say this is essentially a holiday homes case. In a holiday home, one would occupy the holiday home perhaps during the summer. In this case, it was reversed and he occupied the home during the winter for 2 months. And that's the case in which the quality of that occupation was not sufficient. And in fact, on page 65 of the bundle, in answer to a comment from fellow Justice Lewison, the sentence starts, one has to look at the case law in order to discover the relevant principles to apply in any given case. The question the county court judge has to decide is being described as essentially a jury question of fact. The judge must direct himself properly on the law and For that purpose, he must discover the relevant principles from the case law. Having done that, he then applies the relevant principles to the facts. That's not what happened in this case.
Yeah. And again, at page 70 of the bundle, last paragraph, you've got this contrast between a home and a place of convenient resort.
Well, exactly. And I say that the holiday homes, the distinction between the holiday home and the flat in London is a good example of that. Now, the flat in London, whether it's used 1 or 2 nights a week, is part of the continuing pattern of occupation of the individuals or the individual who occupies it. It's continuous, continuing, and is essential to the way in which they occupy property throughout the year. And holiday homes cases are about property essentially used for convenience for a small part of the year. And I said that is a distinction that's drawn here in Regalian securities. And that's why the judge was right to assume the Brakes were in occupation prior to November 2018, because their case is not a holiday home case. This was part and parcel of the way they occupied the premises as a whole, including the cottage. The next case is in the supplementary bundle, tab 10, Hampstead Way. It's the House of Lords. The tenant, again, moved out with his family, but worked night shifts in a nightclub, so would return at 5 AM to the property that he formerly resided in, where his stepson was living, and went to sleep in one of the bedrooms. And he said that was sufficient for residency because it was so regular. And page 80 of the bundle, under the letter C, while the tenant retained the limited use of one room at the flat as described above, the stepson, who was a self-employed computer programmer and engineer, occupied the rest of the flat for all usual living activities. So that's the heart of this case. It's a case about a person living essentially as a lodger in a house and claiming to be resident in that particular physical building. If I just note at page 80, just note at page 82, please. By the letter B, it's said by Lord Brandon that there's no real difference between the words residence or home. We have a home authority to come on to in a moment. And then at page 84, the House of Lords refer to a previously decided decision by the Court of Appeal called Kavanagh. Now that was where there was use of 2 next door properties, sleeping in one and keeping clothes and things in the other. And then by the letter C, well, you'll see, in fact, from the start of that paragraph, your lordships were invited by counsel for the appellants to hold that Kavanagh was wrongly decided. It's not necessary for your lordships to decide that question. And then by the letter C, the further question, that's the further question the Court of Appeal did not ask, was whether the tenant occupied number 21 and number 23 as a combined or composite home. And the facts of that particular case, the leases had originally been granted by the same person. Obviously, in our case, we have a single licence on the face of it in relation to the premises. And then the only real principle we can draw from this is 4 lines from the bottom, which is that the flat was in truth the home not of the tenant who slept there on 5 nights a week and kept his clothes there, but that's of the adult stepson.
Well, you've got his statement of general principle at page 169 of the report.
Yes, sorry, at 1, 2 and 3.
Yeah.
So, all principles we've seen already from the earlier cases. I'm going to, given time, I'm going to skip, I'm afraid, Crawley Borough Council. And move to the main authorities bundle, volume 2, please, which is the Islington Borough Council case in this court from 2012, is on the 11th.
Yeah, which tab?
Sorry, it is tab 25.
25. Yes.
Now, the facts of this case were rather sad. There were a number of children in the originally secured flat. One child who suffered from severe autism. The mother was in a relationship with a man who owned a property 100 miles away in the countryside, and they essentially swapped properties. She went to live in the countryside for multiple years because the son's behaviour as against the daughters was causing damage within the family. So those are the essential facts. But at the bottom of page 404, the test that the court was applying in that case was a slightly different test of the Housing Act 1985, and the second part of that is the occupation was the tenant's only or principal home. But we've seen there isn't really a material distinction between home and residence for these purposes. So in fact, this case, and then on the following page 405, we see the following principles, which are a helpful summary of the decision of this court. And in particular, it talks about the length of the absence, the need for a tenant to rebut the presumption in certain circumstances, that is, the presumption of abandonment. The intention had to be returned by a specific date within a finite period. And then the letter D, we see the thing that's been the constant theme through all these cases. The tenant also had to show that her inward intention was accompanied by some formal outward visible sign of the intention to return, had to be sufficiently substantial and permanent and otherwise adequate to rebut the presumption. Situations where the tenant had another property in which he voluntarily took up full-time residence had to be viewed with particular care to assess whether the tenant ceased to occupy as a home the place where she had formerly lived. So, what are the principles that can be drawn from all that? I say there are three. I'm going to say this very quickly, as I appreciate the time. The first and key principle is that a resident does not lose residency simply by not being physically present on a particular day.
Sorry, just say that again, you're going a bit fast.
Sorry. The first and key principle, a resident does not lose residency simply by not being physically present on a particular day. The question for the court is there an intention to return, subjective, combined with some outward manifestation of that intention to return, objective? And that's in virtually all the cases in residency.
Yeah.
And in respect of two homes cases, one has to be careful, this is my second principle, to ensure that the use or occupation of one or more of those properties is of a sufficient quality to describe it as a residence. So a flat in London during the week, whilst the person works, is sufficient. A holiday home used briefly during the summer is not, which shows that the question of quality of use is connected to the regularity of the occupation and the pattern of use of the property. And we say particular care has to be taken in the cases in which it's accepted that the resident did previously have residency. That's go for investments, Islington Borough Council, and we say our case on the findings the judge made of having ceased to reside. We've got to be particularly careful about testing the proposition that residency has been lost. So that's principle 2A really, it's related to principle 2. Third and final principle, unlikely to be disputed, is that if one uses a property as in Hampstead Way, using one bedroom, or purely for convenience, for example, storing some old clothes, never residing overnight, where someone else lives, then you don't reside in there just because it's a residential property, and that is because in substance the property is a residence of somebody else. But that's not this case. There was no sharing of occupation. So I'm very conscious of the time. I think the court has heard the way we put this case primarily, assuming we even get here, which is that the judge found that the breaks had ceased to reside after the 8th of November, and there is absolutely nothing to show that they ceased to reside there. In fact, the best evidence we have the day before the eviction are the undertakings given to the court, which itself show the subjective and objective elements of intention to return.
Yeah.
And we say if there is a much more wide-ranging question about the position as before the 8th of November, which the judge just didn't do because he was never addressed on it, and this court feels that it can make that assessment on the primary findings of fact, we say this is obviously a case of residency, as the judge clearly thought it was. The quality of the occupation that the Brakes enjoyed of the cottage, in next to formerly part of the same title to the house, over a prolonged period of time, throughout the year continuously, which it was part and parcel of their everyday lives, is clearly sufficient, we say, of a sufficient quality to count as residency. So it's not quite as detailed as I would like to have been, but those are the headline points, and unless I can assist
Yeah.
your lordship, shall I-
Just so that I'm clear, grounds 1 and 3 run together, do they?
Well, I think
I mean, I don't think Mr. Learmont has, or you for that matter, have addressed them separately. They're run together in who's got the better title to possession.
well, the way this case was, so I think the council teams have agreed that we're going to park the question of possession for the consequentials, depending on what the court says about which grounds we've been on, grounds. But the way this case was pleaded is that possession arises whether under ground 1 or under ground 2, because under ground 2.
Well, just so that you know, Mr. Learmont has been forceful in the argument that that Chedington was not entitled to use self-help.
Yes.
But if I can put it this way, that was then and this is now. Now we are before a court, at least they were before Judge Matthews.
Yes.
So the question then is, what is the court going to do once its powers stroke duties are invoked by both sides? Now, that may produce a different outcome as between ground 1, self-help, and ground 3, what remedy is the court going to give?
Yes.
But that's why I ask, are you saying that grounds 1 and 3 stand or fall together?
Well, I mean, we say ground 3, we don't win on either ground 1 or ground 2. We certainly don't win on ground 3. So we say that ground 3 follows on grounds 1 or 2.
And what if you win on ground 1 but lose on ground 3?
Well, that's
Then what?
Well, ground. If we win on ground 1, ground 2 falls away.
Yep.
Because Chedington was not the owner within the meaning of
Yeah.
the 1907 Act. So that falls away. There's then a question, and in fact, my lady friends pointed out towards an email correspondence that they might wish to argue that the proper remedy is not a possession order, but purely damages or something else. So it may be that's an argument that we have to have a different day. But the way it was put below, and the way it's been put on the grounds of appeal, is that we say ground 3 is contingent on succeeding on either grounds 1 or ground 2.
All right. Yes, Mr. Level, you want to add something?
Adopt my learned junior's submission on that. If there was no right for them to take possession, then the family's prior possessory title trumps Chedington's possessory title because it is subsequent in time, and Chedington now, because the licence has lapsed, has no title whatsoever. So that's the order that ought to follow.
Yeah.
And it no longer lies in Chedington's mouth to say that some different order ought to follow. But I appreciate my learned friend now wishes to say something about that. May I just...
Do you want to say it at 2 o'clock, Mr. Sutcliffe?
My lord, all I wanted to do was to hand up to the court a letter that's been received from the solicitors to the Brakes trustees.
Yes, I've seen it.
Yeah, we've had
Seen
that.
that.
We've had that. It's been sent already.
My Lord, if it's possible, just take one more minute of
Yes.
your Lordship's time, just in answer to a point your Lordship made a moment ago about the hypothetical example of a landlord who allows a tenant at the termination of his tenancy to remain in occupation rent-free, and whether that would be turn the licence into an excluded licence, the tenancy into an excluded tenancy. And I said no, but on the technical ground that that's not what the Act says. But there's also a sort of substantive ground that's occurred to me, of course, because if your Lordship were right, that would generate a huge loophole in the protection of the Act. The landlord would make an offer the tenant couldn't refuse to have a rent-free period, and so that's the answer to that. And finally, just to supplement what my learned friend says about residence, the cases are difficult to reconcile, but we need to bear in mind the policy behind the acts in question. The Rent Act gives very, very powerful protection to tenants, security of tenure, rent protection as well. The Protection from Eviction Act is a very light touch act by comparison. It's not depriving anyone of any rights at all, just saying do it the proper way.
Trouble is that the N and Lewisham case was about the Protection from Eviction Act.
Yes. I'm not saying it's a complete answer to the difficulty of reconciling the cases, but it may assist.
Yeah.
Great.
Right. Well, since we have a lot to get through, I'm going to say 2 o'clock.
All right.
Sorry for overrunning slightly. Thank you for your